At 3:17 this morning, the United States Treasury Department executed an asset freeze order targeting Mar-a-Lago properties and associated financial accounts in what three independent sources, two from Treasury's Enforcement Division, one from an aide to the Senate Banking Committee, are calling the most aggressive use of federal financial authority against a former president in American history. What happened in those pre-dawn hours represents a threshold moment that has never occurred in 249 years of American governance. The federal government treating a former president's primary residence and business operations as if they were a sanctioned foreign entity or a criminal enterprise subject to immediate financial quarantine. I need you to understand the weight of what I am about to tell you. The order, which was transmitted through the Treasury's Office of Foreign Assets Control at exactly 3:17 Mend Eastern Time, didn't just freeze bank accounts. According to documents obtained by sources with direct knowledge of the enforcement action, the order encompasses all real property titles, business operating accounts, payroll systems, vendor contracts, and even the basic utility accounts that keep Mar-a-Lago's lights on and water running. This is not a civil penalty. This is not a negotiated settlement. This is the nuclear option in federal financial enforcement, and it was deployed in the middle of the night with zero advance warning to the target or his legal team. If you care about what happens when the full weight of federal enforcement power gets aimed at any American, regardless of who they are or what they've done, you need to subscribe to this channel right now and turn on notifications, because what happened in those 3 hours between midnight and dawn will determine whether the constitutional protections around property rights and due process still function when the government decides someone has crossed a line that cannot be uncrossed. Hit that subscribe button and turn on notifications, because the next 96 hours will reveal whether our system still has guardrails or whether we've entered a new era where Treasury enforcement becomes the weapon of choice when conventional legal processes move too slowly for political comfort. Here's what we know from multiple sources who were briefed within hours of the order's execution. The asset freeze designation came through OFAC, the same division that handles sanctions against terrorist organizations, drug cartels, and hostile foreign governments. The legal mechanism being used is Section 311 of the USA Patriot Act, which allows Treasury to designate entities as primary money laundering concerns requiring immediate financial isolation. Three constitutional scholars, two from Georgetown Law, one from Yale, confirmed in separate interviews this morning that this marks the first time in the statute's 23-year history that it has been applied to a former president's domestic property holdings. The precedent being set here extends far beyond one individual or one property. What Treasury established at 3:17 this morning is a template for financial quarantine that can be deployed against any American if the enforcement rationale meets the statutory threshold, and that threshold has never been publicly tested against constitutional property protections in any federal court. According to sources familiar with the execution sequence, the freeze order was coordinated across 4 federal agencies simultaneously. Treasury's Financial Crimes Enforcement Network transmitted the designation to every major bank holding Mar-a-Lago accounts at 3:17 The Department of Homeland Security dispatched Federal Protective Service officers to secure the property perimeter at 3:22 a.m. The Internal Revenue Service Criminal Investigation Division placed holds on all associated business tax accounts at 3:25 a.m. The Securities and Exchange Commission flagged all corporate entities with ownership ties to the property at 3:31 a.m. The operational coordination reveals months of planning with execution timing designed to achieve complete financial isolation before any legal response could be mobilized. By the time the sun rose over Palm Beach at 6:47 a.m., every financial institution in the United States had received notification that Mar-a-Lago and its associated entities were now subject to the same transactional restrictions as designated terrorist organizations. The sealed court filing that authorized this action was submitted to the Foreign Intelligence Surveillance Court, not to regular federal district court where property disputes are normally adjudicated. According to legal analysts who reviewed the procedural pathway, the FISA court jurisdiction suggests the underlying investigation involves either foreign intelligence concerns or national security matters that cannot be litigated in open court. The filing itself remains classified, but sources indicate it contains 847 pages of financial transaction analysis, intercepted communications, and forensic accounting evidence compiled over an 18-month investigation that nobody outside a small group of senior Treasury officials and federal prosecutors knew was underway. Let me walk you through exactly how we got here, because the timeline matters enormously, and the sequence reveals a pattern of escalating federal enforcement that has been building for months, while most media attention focused elsewhere. Tuesday, November 19th, 2024. The Treasury Department's Financial Crimes Enforcement Network received a suspicious activity report from Deutsche Bank, flagging a series of wire transfers totaling $47 million moving through accounts associated with Mar-a-Lago properties. The SR, which is mandatory reporting that banks must file when they detect potentially illicit financial activity, noted that the transfers originated from shell companies registered in the Cayman Islands and moved through 3 intermediary accounts before landing in Florida. Standard procedure requires FinCEN analysts to review all SRs within 30 days, but according to sources, this particular report was flagged for immediate escalation within 4 hours because the transaction patterns matched known money laundering typologies. December 3, 2024. FinCEN opened a full investigation codenamed Gilded Asset, assigning a team of 14 forensic accountants and financial intelligence analysts to reconstruct the complete transaction history of all accounts associated with Mar-a-Lago going back 7 years. Sources indicate the investigation's scope expanded within 2 weeks, when analysts discovered that the $47 million in suspicious transfers represented only a small portion of a much larger financial network involving over $200 million in transactions that could not be explained by legitimate business operations. January 14, 2025. The investigation reached a critical threshold when Treasury analysts presented preliminary findings to the Deputy Attorney General in a classified briefing lasting 4 hours. According to someone who was read into the briefing materials, the evidence showed systematic use of Mar-a-Lago accounts to layer and integrate funds from undisclosed foreign sources, using techniques that mirror professional money laundering operations. The briefing included intercepted communications suggesting knowledge and intent to conceal the sources of funds, which elevates the conduct from potential civil violations to potential criminal enterprise. February 2, 2025. The Treasury Secretary personally authorized the transition from investigation to enforcement action, signing off on the use of Section 311 Patriot Act authorities. This decision required sign-off from the National Security Council because designating a former president's property under terrorism financing statutes carries obvious political and constitutional implications. Sources indicate there was significant internal debate about whether to pursue conventional criminal prosecution first, but enforcement officials concluded that the ongoing transactions posed such substantial money laundering risk that immediate financial quarantine was necessary to prevent further fund integration. February 28, 2025, Treasury submitted the sealed enforcement application to the FISA Court. The 847-page filing included financial transaction evidence, intercepted communications, expert declarations from forensic accountants, and legal memoranda addressing the constitutional questions about applying Patriot Act authorities to a former president. The court held an ex parte hearing, meaning no defense counsel was present or even notified, and issued the freeze authorization within 36 hours. March 11, 2025, at 3:17 a.m., the enforcement operation launched simultaneously across all target accounts and entities. Federal Protective Service officers arrived at Mar-a-Lago's main gates, with the court order at 3:22 a.m., informing security personnel that the property was now under federal financial restriction and that all business operations must cease immediately, pending resolution of the enforcement action. Now here's where this becomes something far more significant than a single enforcement action. The individuals behind the decision to use Patriot Act authorities in this context are not political appointees looking for headlines. Treasury's Enforcement Division operates with career professionals who have spent decades building money laundering cases against the most sophisticated criminal organizations in the world. The decision to deploy these tools against a former president required legal analysis, concluding that the evidence meets the statutory threshold regardless of the target's identity or political position. If you're finding this valuable and you want to understand what comes next, hit that like button right now, because this story is about to get significantly more complicated, and you'll want to be here for all of it. Every like tells the algorithm this analysis matters and helps push this content to more people who deserve to know what's really happening before the spin machine has time to bury the truth under layers of political narrative. Let me tell you about the man whose financial empire just got frozen at 3:17 this morning. This is someone who has spent 50 years building a business reputation on luxury branding, high-end real estate, and cultivating an image of extraordinary wealth. That image became the foundation of a political movement built on the promise of business acumen applied to government. But according to the Treasury Department's forensic analysis, the financial reality beneath that image involves transaction patterns that professional money laundering investigators recognize from cases involving international organized crime. The evidence Treasury compiled over 18 months reveals a network of shell companies, intermediary accounts, and layered transactions designed to obscure the origin of funds moving into Mar-a-Lago operations. Sources familiar with the investigation describe a financial architecture where money enters through offshore entities, moves through multiple jurisdictions to break the transaction trail, then integrates into legitimate business accounts as if it originated from normal commercial activity. This is not sophisticated accounting to minimize taxes. This is the operational methodology of laundering illicit funds, and Treasury's case is built on demonstrating that the pattern is too consistent, too complex, and too carefully structured to be anything other than intentional. The decision to freeze assets at 3:17 this morning reflects Treasury's assessment that conventional prosecution timelines, which could take years of litigation before any financial restrictions take effect, would allow the enterprise to continue operating and potentially moving funds beyond federal reach. The Patriot Act authorities exist precisely for situations where the government concludes that immediate financial quarantine is necessary to protect the integrity of the U.S. financial system, and Treasury made the determination that this situation meets that threshold. Here's what concerns me most about what happened this morning and why the next 96 hours will reveal whether our constitutional system still has the capacity to enforce accountability when someone with extraordinary resources and political influence faces federal enforcement. The asset freeze is not a conviction. It is not even an indictment. It is an administrative enforcement action that can be executed through FISA court authorization without the due process protections of regular criminal proceedings. The target gets no advance notice, no opportunity to contest the evidence before the freeze takes effect, and no public court proceeding where the allegations must be proven beyond reasonable doubt. The constitutional questions are profound and genuinely uncharted. The Fifth Amendment protects property rights and requires due process before the government can deprive anyone of property. But the Patriot Act authorities were specifically designed to bypass normal due process timelines when dealing with terrorism financing and money laundering threats. The tension between these two constitutional frameworks has never been tested in a case involving a former president's primary residence and business operations. The legal battle that will unfold over the next weeks and months will determine whether Patriot Act enforcement powers can survive constitutional challenge when applied to a U.S. citizen's domestic property, or whether the courts will rule that the government overstepped its authority regardless of the underlying evidence. And it gets worse. According to sources familiar with the sealed filing, the evidence Treasury presented to the FISA court includes intercepted communications suggesting knowledge and intent to structure transactions in ways designed to evade reporting requirements and conceal the source of funds. If those communications are eventually made public, and there are serious questions about whether FISA-authorized intercepts can ever be used in regular criminal proceedings, they would transform this from an administrative enforcement matter into potential criminal charges carrying decades of prison time. Subscribe now if you want to follow where this investigation leads, because the implications are staggering and mainstream media will be 3 hours behind everything I'm showing you. This channel brings you the analysis and the documentation that others won't touch because they're terrified of the blowback. Hit subscribe and turn on notifications because when the communications get unsealed, when the FISA court's reasoning becomes public, when we find out exactly what Treasury knows that justified freezing a former president's assets at 3:17 in the morning, you will see the detailed breakdown here immediately. But wait, there's something even worse I haven't told you yet. The timing of this enforcement action, executed on March 11, exactly 30 days before the next presidential primary debate, and 62 days before the Republican National Convention, raises questions that legal analysts are already debating in real time. Some are arguing this represents legitimate enforcement of financial crimes statutes, regardless of political calendar. Others are questioning whether the decision to execute the freeze now, rather than waiting for conventional prosecution, reflects political calculation about disrupting a potential 2028 campaign before it fully materializes. The truth is probably more complex than either narrative suggests. According to sources familiar with the investigation timeline, Treasury's evidentiary case reached completion in mid-February, at which point enforcement officials faced a decision about whether to proceed with immediate financial quarantine or to continue monitoring transactions while building a conventional criminal case. The decision to proceed with immediate enforcement reflects Treasury's assessment that ongoing transactions posed sufficient money laundering risk that delay was not justifiable. But the political implications of that timing decision are unavoidable, and they will fuel conspiracy theories and allegations of weaponized government regardless of the underlying evidence quality. Former federal prosecutor Andrew McCarthy told Fox News this morning that asset freezes under Patriot Act authorities are supposed to be reserved for the most serious national security and terrorism, financing cases, and applying them to a former president's domestic property represents either an extraordinary expansion of enforcement discretion or evidence of conduct so egregious that conventional tools were insufficient. Either interpretation is deeply troubling for different reasons. Constitutional law professor Jonathan Turley emphasized that the lack of advance notice and the use of FISA court jurisdiction create serious due process concerns that will definitely be challenged. And those challenges will test whether Patriot Act authorities can survive judicial review when applied to U.S. citizens' domestic property. Here's where it gets really bad. The asset freeze doesn't just affect Mar-a-Lago itself. According to the enforcement order, all associated business entities, subsidiary companies, and even personal accounts with ownership ties to the designated property are now subject to the same restrictions. That means vendors cannot be paid, employees cannot receive paychecks, property taxes cannot be transmitted, utility bills cannot be processed. The property is not physically seized, but it is financially paralyzed, unable to conduct any transactions until the designation is lifted or successfully challenged in court. The human impact of that paralysis creates its own set of legal and moral questions. Mar-a-Lago employs approximately 350 people in various roles from grounds maintenance to hospitality services. Those employees woke up this morning to discover that their employer cannot process payroll and has no timeline for when normal operations might resume. The property hosts events that were booked months in advance, some of them weddings and anniversary celebrations for families who saved for years to afford the venue. Those events cannot proceed because the property cannot accept payment or provide contracted services. The collateral damage of financial quarantine extends far beyond the designated target, affecting innocent third parties who had no knowledge of any alleged money laundering activity. Make sure you're subscribed with notifications turned on because this story is far from finished. When the legal challenges get filed, when we see the first court proceedings where the evidence might become partially public, when Treasury has to defend the decision to use Patriot Act authorities in this unprecedented context, you will see detailed analysis here breaking down every legal argument, every piece of evidence that gets revealed, and every implication for how federal enforcement power can be used going forward. This is not just about one person or one property. This is about the scope of government power and the limits of constitutional protection. And what gets decided here will establish precedents affecting every American for generations. Let me bring this together, because we are running out of time and the clock is ticking faster than most people realize. What happened at 3:17 this morning represents a collision between federal enforcement power at its most aggressive and constitutional property protections that have existed since the founding. The government executed a financial quarantine using authorities designed for terrorism and money laundering cases. The target is a former president whose political movement remains powerful and whose supporters will view this as persecution regardless of evidence. The legal battle that unfolds will test whether Patriot Act enforcement can survive constitutional challenge when wielded against domestic property owned by U.S. citizens. Let me lay out the 4 scenarios that are now on the table. Scenario 1. Treasury's evidence is overwhelming and survives legal challenge. Probability 35%. In this scenario, the forensic accounting and intercepted communications prove money laundering activity that meets statutory thresholds. The FISA court's designation withstands constitutional review. The property remains frozen pending criminal prosecution. The implications would establish that Patriot Act authorities can be used domestically against any American when evidence reaches the required threshold, fundamentally expanding federal enforcement discretion beyond the terrorism context for which these tools were originally designed. Scenario 2. Constitutional challenge succeeds and the freeze gets lifted. Probability 40%. In this scenario, federal courts rule that applying Patriot Act authorities to a former president's domestic residence violates due process protections regardless of the underlying evidence. The property freeze gets vacated. Treasury must pursue conventional prosecution with normal constitutional safeguards. The implications would establish meaningful limits on Patriot Act enforcement power, reinforcing that even terrorism statutes must respect core constitutional protections when applied to citizens' domestic property. Scenario 3. Political settlement through negotiated resolution. Probability 20%. In this scenario, behind closed doors negotiations result in a settlement where the property gets divested or transferred to independent management in exchange for lifting the freeze without criminal prosecution. This would represent the path of least constitutional confrontation, allowing both sides to avoid the precedent-setting court battle. The implications would leave the constitutional questions unresolved while removing the immediate crisis, but would fuel conspiracy theories on all sides about backroom deals protecting the powerful. Scenario 4. Constitutional crisis through defiance. Probability 5%. In this scenario, state authorities in Florida challenge federal enforcement jurisdiction and attempt to assert state sovereignty over property within state borders. This would trigger a federalism confrontation that could escalate to constitutional crisis if state and federal law enforcement come into direct conflict. The implications would be catastrophic for rule of law and institutional stability. But here's why this matters beyond this one case and beyond any individual. The stakes go far beyond one enforcement action or one designated property. This is a test case for the scope of federal financial enforcement power in the modern era. If Treasury can freeze a former president's primary residence at 3:17 in the morning using Patriot Act authorities with no advance notice and no public court proceedings, that power exists to be used against anyone whose financial conduct triggers the same statutory thresholds. The precedent being set will determine whether Americans still have meaningful property rights protections or whether those protections evaporate when federal enforcement officials conclude that financial crimes evidence justifies immediate quarantine. So what can you actually do about this? Because I know a lot of you are watching this feeling powerless in the face of enforcement actions that seem to expand government authority in ways that should concern everyone, regardless of political position. First, contact your representatives in Congress and demand oversight hearings on Treasury's use of Patriot Act authorities for domestic enforcement. The Senate Banking Committee and House Financial Services Committee have jurisdiction over these matters and the constitutional authority to demand answers. Public pressure works when enough citizens make clear that congressional oversight is not optional. Second, support legal defense funds that will challenge this enforcement action on constitutional grounds. Regardless of anyone's opinion about the target, the constitutional questions about property rights and due process affect every American. These challenges require enormous resources, and experienced constitutional litigators and public support helps ensure the challenges can be sustained through years of federal court proceedings. Third, stay informed through independent analysis that isn't filtered through political spin. Subscribe to this channel right now, because in the next 72 hours, everything could change. When the first legal challenges get filed, when any portion of the sealed evidence becomes public, when federal courts begin addressing the constitutional questions, you will see comprehensive breakdown here, explaining what it means, what comes next, and what it reveals about the scope of federal enforcement power. The next 96 hours will determine whether this enforcement action stands or falls, whether constitutional challenges gain traction, whether political pressure forces settlement negotiations, or whether we're heading toward extended legal warfare testing, fundamental questions about property rights and federal enforcement discretion. This is history unfolding in real time, and what gets decided here will establish precedents that determine how government power can be used against any American for decades to come. Drop a comment below. Do you think Treasury overstepped constitutional limits, or is this legitimate enforcement against serious financial crimes? What scenario do you think is most likely? I read every comment, and your perspectives shape how I cover these developing stories.